Your Excellencies, distinguished guests, ladies and gentlemen, good morning. My name is Hemi, and I'm going to serve as your MC today for the 12th Asia-Pacific ADR Conference, which is co-hosted by the UNCITRAL, the Ministry of Justice of the Republic of Korea, and KCAB International and the ICC. Well, it's indeed my great honor and pleasure to be part of such a meaningful event. And on behalf of our host, I would like to express my sincere gratitude and welcome to all of you, both online and offline attendees, for taking the time to be with us here today. And in particular, we would like to thank our honored guests who have traveled long distances to be with us here today. So thank you so much for coming, and we hope that we're going to have a very constructive time today. So, ladies and gentlemen, without further ado, let us begin the 12th Asia-Pacific ADR Conference in earnest. Well, first of all, it is my great joy and privilege to announce that in order to officially commence the opening ceremony of this conference, the Honorable Mr. Han Dong-hoon, the Minister for Justice of the Republic of Korea, will deliver his opening remarks. So now let me invite our Minister up to the podium. Minister Han, please come forward. Ladies and gentlemen, please welcome him with a big round of applause.
안녕하십니까?
Good morning, distinguished guests, ladies and gentlemen. I am Han Dong-hoon, Minister of Justice of the Republic of Korea. I'm very pleased to host the 12th Asia-Pacific ADR Conference, New World, No Map, with the attendance of expert guests from countries all over the world. First of all, please allow me to express my gratitude to UNCITRAL, KCAB, and also ICC for their efforts in hosting this event together. Furthermore, I would like to extend a sincere gratitude and welcome to all the experts who have taken time out of their busy schedules for presentations and also discussions, as well as everyone who has participated in today's event. The first topic of this year's conference is the role of arbitration institutions and practitioners in the arbitration field in the post-COVID-19 and digital era of today. Ladies and gentlemen, the COVID-19 pandemic is over. I had the chance to greet everyone last year online, but I'm quite pleased and excited that we are able to finally meet in person today. Throughout the 3 years of COVID-19, alternative dispute resolution faced various challenges, such as lack of chance to meet in person and also delay of procedures. But so, each nation has continued to make improvements by turning crises into opportunities via various efforts and innovations, such as online case management, remote hearing, and expedited arbitration. And now it's the time to prepare for a post-COVID-19 world. We need to consider the roles of arbitration institutions and the practitioners in the post-COVID-19 and digital era, and the direction of the efforts made, as well as the innovations taken by all nations. At this year's conference, topics that recently have received a significant attention in the alternative dispute resolution field, such as ISDS and digital finance, will be discussed. In the past, ISDS existed merely as a phrase in the treaty documents, but the number of ISDS cases has grown each year as international trade has become active. At the same time, there are also voices of concerns about the ISDS system in terms of costs and delays in the procedures. As much as the international community is seeking various ways to improve the ISDS systems, I hope ways in which ISDS can achieve progress will be put forth via active discussions at this year's conference. Digital finance is just as important topic as ISDS in the arbitration world. The digital shift in finance is being accelerated with the adoption of new digital technologies such as big data, AI, cloud, as well as the mainstream popularity of smartphones. But such change is inevitably going to bring about new forms of disputes. At this year's conference, I hope that constructive proposals and in-depth discussions on how alternative dispute resolution can contribute to resolution of disputes on digital assets will take place. This year's forum is the 12th meeting of the Asia-Pacific ADR Conference. Since the Republic of Korea Ministry of Justice is co-hosting of the first meeting, the conference has gained a reputation as a truly global event in the field of ADR. The Korean Ministry of Justice is currently in discussions to bring in the PCA regional office to Korea in hopes to vitalize international arbitration in the Asia-Pacific region. Also, as a responsible member of the international community, to actively participate in forming international norms and to strengthen its capabilities in the international investment disputes, the Ministry of Justice has restructured its organization and increased the number of divisions dedicated to international legal affairs from 1 to 3 and newly installed the International Legal Affairs Department. The Korean Ministry of Justice will continue to work hard so that the Asia-Pacific region, as well as Korea, can become a global center in the realm of ADR. I sincerely request that you join us in making this conference as an opportunity for such an objective. Once again, I would like to extend my warm welcome to our honored guests from both home and abroad, and please allow me to express my wishes for everyone's health and happiness. Thank you.
The Honorable Mr. Han Dong-hoon, the Minister for Justice of the Republic of Korea, has just delivered an excellent opening speech. Despite his busy schedule, he has kindly taken the time to be with us here today. So thank you so much once again, Minister Han. And next, I'm very pleased to announce that the Honorable Madam Anna Jubin Brett, Secretary of the United Nations Commission on International Trade Law, which is better known as UNCITRAL, will deliver her congratulatory remarks. Ladies and gentlemen, please welcome her with a big round of applause.
Your Excellency, Mr. Han Dong-hoon, Minister of Justice of the Republic of Korea, Mr. Soo-seok Mang, President of KCAB, Excellencies, distinguished speakers and guests, dear friends of arbitration and of UNCITRAL. It's my great honor to deliver these congratulatory remarks on the occasion of the 12th iteration of the Asia-Pacific ADR Conference. As part of the ADR Festival, it has over the years become a benchmark for discussing cutting-edge developments in dispute resolution in the region and beyond. It is no coincidence that UNCITRAL's Regional Center for Asia and the Pacific is in its 12th year of operation, as this annual conference was the flagship event launched by the United Nations Commission on International Trade Law, the Ministry of Justice, and KCAB, as it established its presence in Incheon. I'm very honored to have attended the conference every year very faithfully since joining UNCITRAL. This year's theme, New World, No Map, perfectly aligns with the times we are currently living. Whether in alternative dispute resolution, in the economy worldwide, but also in the geopolitics, we are living interesting and difficult times. But it also aligns perfectly with UNCITRAL's mandate. As the core legal body in the United Nations system in the field of international trade law, UNCITRAL's mandate is to further the progressive harmonization, but also the modernization of rules facilitating trade and investment, and to achieve conducive legal reform through complementary twin means of, first, remaining responsive to the contemporary commercial landscape, and second, reflecting worldwide consensus of the different legal and economic systems. As globalization and digitization have seen the world become increasingly economically interdependent, the importance of developing and maintaining a robust cross-country, cross-border legal framework to increase legal certainty and decrease risks and transactional costs, including for the digitization of trade and for dispute settlement, cannot be overstated. Today, we will examine the current ADR environment, assess what the new digital age of ADR will bring, review the changing ISDS landscape, and look further into the digital jungle of new technologies and new industries. As you will hear from me and my colleagues, UNCITRAL is heavily involved in all such areas of work, including also with respect to climate change mitigation and related disputes. And we look forward to contributing to this new work by providing a legal framework, maps, to guide legislators as well as users of ADR. I also seize this opportunity to recall that UNCITRAL's texts on digital trade and electronic commerce have already been adopted in over 100 states. Building on this significant legacy, UNCITRAL has recently prepared legislative texts that are considered by stakeholders particularly timely and relevant. The effects of the COVID-19 pandemic that Mr. Minister also alluded to on trade have highlighted the need to build a resilient and robust supply chain accompanied by the full digitization of all commercial documents and the assurance of data quality of the messages exchanged, for instance, with regard to their integrity and origin. The 2017 UNCITRAL Model Law on Electronic Transferable Records and the 2022 UNCITRAL Model Law on the use and cross-border recognition of digital identity management and trust services provides the legal building blocks to achieve that goal. As discussed at the flagship event, the Incheon Law and Business Forum, organized with the Ministry of Justice and Incheon City recently in September. Themed From Documents to Data, Legal and Commercial Solutions for Digital Trade, this year's forum garnered over 4,500 attendants and viewers globally and focused on the legal and business implications of paperless trade facilitation, including pilot projects and business solutions for its implementations. And may I open a parenthesis here, talking to ADR specialists and experts, to have a little bit of introspection of how far behind we are and conservative we are in this area of the law, as opposed to digital commerce that is already riding far ahead. In addition, Working Group 4 is continuing its exploration of the frontiers of innovation and law by working on contracts automation, including through artificial intelligence, and we will hear a lot about its impact on international dispute resolution, and on transactions in data. These two closely related topics get to the heart of the digital transformation. With the digital economy forming an important part of UNCITRAL's work program, today's invigorating discussions on how it will impact the ADR ecosystem, and not on how it might, but how it is already impacting the ADR ecosystem, and how a legally enabling environment for international trade in this new area could be strengthened, should be illuminating indeed. I very much look forward to these discussions. My thanks again to our co-organizers and old friends for this opportunity, and best wishes for a very successful conference. I thank you very much.
The Honorable Madam Anna Jubin-Brett, Secretary of the United Nations Commission on International Trade Law, which is better known as UNCITRAL, gave us an insightful opening speech. Thank you very much, Madam Secretary. And next, the Honorable Mr. Soo Seok-meng, the President of the Korean Commercial Arbitration Board, will deliver his congratulatory remarks. Ladies and gentlemen, please welcome President Meng with a warm round of applause.
예, 여러분.
Good morning, ladies and gentlemen. I am Soo Seok-meng, President of the Korean Commercial Arbitration Board, aka KCAB. First, I would like to welcome all the participants to Korea. In this very beautiful autumn day, it is my honor and pleasure to welcome everyone to the 12th Asia Pacific ADR conference. I understand that we have many arbitration experts from both home and abroad, so welcome once again. I would also like to express my deepest gratitude on behalf of the KCAB to the co-hosting institutions, including the Ministry of Justice of Korea and Minister Han Dong-hoon, as well as Ms. Anna Jubin-Brett, Secretary General of the CITRAL, and Ms. Claudia Solomon, President of the International Court of Arbitration of the International Chamber of Commerce, for successfully leading this event over the past decade. This ADR conference, under the theme of New World, New Map, aims to discuss the direction of international arbitration in the post-pandemic and digital transformation era and address practical issues. Today's conference will consist of 4 sessions. I would like to take this moment to thank each session's moderators and speakers for taking their time to attend this event in person amid their busy schedules. In the first session, key representatives of major international arbitration institutions, including the KCAB, will discuss and introduce how international arbitration institutions have responded to systematic changes due to the end of the pandemic era and the major issues each institution is facing. The second session will provide insights into international arbitration practice by major practitioners. In particular, considering the recent digital transformation era, practitioners will share their experiences and perspectives on how international arbitration practice is being influenced and is changing, as well as how new technologies can be utilized in the ADR field. In the third session, we will focus on the highly relevant topic of investor-state dispute settlement, or ISDS, including recent major issues and future prospects. Renowned investment arbitration experts from various fields, such as international organizations, academia, and practice, will discuss procedural rule changes and also other key issues in this field. The final 4th session will examine the current state of digital finance in areas such as virtual assets and fintech, which have become a reality and are expected to expand further. Experienced practitioners are expected to share their latest information and insights on resolving disputes related to these topics. These sessions of the conference have illustrated the Korean Commercial Arbitration Board's dedication to providing valuable insights that align with its reputation as a prominent international arbitration institution in Northeast Asia beyond the borders of Korea. As Minister Han earlier mentioned, the goal is to make Korea the hub of international arbitration. So going beyond Korea, my wish and my aim is to make Korea a leading arbitration institution in the region. It is truly meaningful for me to have a chance to meet everyone in person here at the conference after nearly 4 years. I sincerely hope that this gathering today serves as an opportunity to gain valuable insights into the recent trends and prospects of the global ADR system. Thank you very much.
The Honorable Mr. Soo Seok-mang, the President of the Korean Commercial Arbitration Board, has delivered brilliant congratulatory remarks on the occasion of the 12th Asia-Pacific ADR Conference. Thank you very much once again. So far we have heard from 3 honorable speakers, and of course, the highly anticipated keynote speech will take place pretty soon, but now we have to rearrange our stage for our next session. So if you're joining us on site, please remain seated, and those of you who are joining us online, please stay tuned. Thank you. Well, now it's time for our keynote speech, which will be delivered by the Honorable Mr. Christopher Lau, Senior Counsel and the Chartered Arbitrator of 3 Verulam Buildings Barristers. And his keynote speech is titled New World, No Map. And to give you a brief introduction of our keynote speaker, as a Senior Counsel and Chartered Arbitrator, Mr. Christopher Lau is recognized as one of the most experienced arbitrators in Singapore, and he is also considered as one of the most in-demand arbitrators in the Asia-Pacific region. And he served in over 200 international arbitrations conducted either on ad hoc basis or under various arbitration roles, including UNCITRAL, KCAB, ICC, HK, IAC, SIAC, and ICDR. And he has also served as a mediator in commercial, construction, and shareholder disputes, both in international and domestic settings. And finally, yes, we are ready to listen to the long-awaited keynote speech titled New World, No Map, which will be delivered by the Honorable Mr. Christopher Lau. So ladies and gentlemen, please welcome him with a big round of applause.
Ms. Anna Joubin-Bray, Secretary of UNCITRAL, Ms. Meg Kinnear, Secretary of ICSID, Mr. Su Siok Meng, President of KCAB, esteemed members of the organizing committee for this conference, distinguished ladies and gentlemen, good morning and welcome to the future. We are in the year 2023. Our world was once thought to be flat. It was then discovered that in fact it was round. At first, there were many blank spaces on the map. Slowly, this filled up. Fewer and fewer blank spaces remain until there were none. But does that mean we know how to navigate the world we presently live in? Or are we finding ourselves in uncharted waters? As an example of how easily the known can turn into the unknown, I would refer to an article in the London Financial Times earlier this year. In it, Gillian Tett, now chair of the Financial Times editorial board and the US editor-at-large, compared the 3 banking crises she had covered in the course of her career. In respect of the latest crisis, namely the collapse of the Silicon Valley Bank, she identified an inconsistency in cultures as one of the key reasons for the collapse. SVB's culture emulated its tech and startup client base, including its willingness to take bold bets. Risk management culture, as it is usually practiced in banks, with good reason, is, however, antithetical to the Silicon Valley culture. Looking to the future, Ms. Tett emphasized that, and I quote, "Right now, there is another crucial cultural issue that potentially matters even more, and that is consumer behavior." Torsten Slock, an economist at Apollo, notes that the share of US households using mobile banking increased from 39% in 2013 to 66% in 2021. Until now, the models used in finance do not seem to have taken account of the fact that consumer behavior online might be different from that in the old-fashioned physical banking world. But a striking feature about American banks, even before the March panic, was that consumers were moving money out of low-paying deposit accounts into better-yielding money market funds at a dramatically faster pace than at similar points in history. That might imply that greater information transparency accelerates consumer reaction to news, even outside crisis, increasing the risk of herding. But in either way, we urgently need, she opines, some behavioral finance analysis, since American banks will stay healthy only if they hang on to deposits, and digital herding could increase the risk in other markets, such as treasury bonds, if shocks emerge there too. So what all this shows is how quickly we, fueled by technological progress, can find ourselves in unknown territory. One technical advance released to the public less than a year ago has ushered in no less than a new era. It has dominated the discussions at every major ADR conference and will, for the foreseeable future, continue to do so. I'm referring, of course, to artificial intelligence, or AI for short. To use or not to use, that, I suggest, is a question which we might, as of today, no longer need to ask. Why? Because if all goes as planned, Microsoft 365 Copilot will be generally available for enterprise customers from today. Copilot effectively seeks to integrate GPT-4-based AI in all those Microsoft 365 products which we are only too familiar with. What might be possible once Copilot operates, as it is intended to do, was illustrated by a trio of lawyers from Allen & Overy in a paper published only 2 weeks ago in GAR. In that paper, Martin McGough, Katrina Lemon, and Alexander Calthrop considered artificial intelligence in arbitration, evidentiary issues, and prospects. They posited that AI would be able to, and I quote, proactively look for evidence of claims as it had access to the company's contracts, and one would automatically review all emails, documents, and other data related to the contract's performance. 2, compile evidence, notify the user of possible breaches of contracts, and 3, suggest next steps, including diarizing deadlines for contractual notices, preparing draft claim letters, or drafting talking points for inter-party meetings, possibly for engaging in settlement discussions. In short, it sounds like the beginning of the end for the legal profession, at least as we know it. Of course, what impact AI will ultimately have remains to be seen. But what is clear at this point is that AI has arrived in ADR. The question we should then be asking is, how do we deal with this? What could an arbitral tribunal do in arbitral proceedings? And what should perhaps the broader ADR community do? Let's consider the first question in a little more detail. As a first step, a tribunal will need to consider the legal framework governing the arbitral proceedings. As far as I'm aware, China is presently the only jurisdiction that has some framework in place on the use of AI in legal and arbitration proceedings. But that is not a reason for a tribunal in proceedings which do not involve any Chinese parties to be complacent. That is because from present discussions on AI legislation currently in the pipeline, it transpires that it is more likely than not that AI legislation will have extraterritorial effects. The EU, for example, envisages that its AI law, which is expected to come into force at the end of 2025 at the earliest, will apply if what is generated by the AI system, even if that system is located outside the EU, is intended to be used in the EU. On the face of it, This means that an award that is to be enforced in the EU, even if it is rendered in a jurisdiction outside the EU, will be subject to EU AI legislation. If AI was used in the course of those arbitral proceedings, as Magal, Lemon, and Calthrop noted in their paper, and I quote, "The onus will be on arbitration practitioners to ensure any use of AI complies with applicable regulations. This may extend beyond regulations in their home jurisdiction to include the laws of the seat and place of enforcement. It is not inconceivable that parties may soon attempt to resist enforcement of an award on the grounds that the other side's use of AI was illegal under one of the applicable laws to the arbitration. Given that it is incumbent on a tribunal to render an enforceable award, it does appear prudent going forward that a tribunal ascertains whether the use of AI has been expressly legislated on in the jurisdictions that may be of relevance. Such jurisdictions would include the seat of the arbitration and could include the party's legal domicile, the jurisdictions counsel practice in, the tribunal members' jurisdictions, and where foreseeable, any enforcement jurisdictions. I appreciate this is quite a lengthy catalogue of jurisdictions. However, for the foreseeable future, and until there's more certainty on the legal framework governing AI, it may be necessary to enlist the parties' assistance and seek their input, ideally at the outset of an arbitration. But this, of course, presumes that the past, present, or future use of AI is known to the participants in the arbitration. For such use to be known, disclosure, however, would need to be made. Disclosure of the use of AI, however, is one aspect where currently the views differ. Guideline 3 of the Silicon Valley Arbitration and Mediation Center draft guidelines on the use of AI in arbitration deals with disclosure. This guideline, which has presently 2 alternatives, is quite an extensive provision. Adopting a multi-pronged approach, it seeks to address a number of questions, starting with, do parties and/or arbitrators have to disclose the use of AI tools? If so, in what circumstances? What information concerning the use of AI would need to be disclosed? In what circumstances would a party be entitled to make an application for disclosure concerning the use of AI? And when would an arbitral tribunal, suo motu, be entitled to order disclosure on this? Whilst the guideline addresses the use of AI by parties, experts, and tribunals, it does not, however, refer to, for example, tribunal secretaries. Therefore, depending on the circumstances, the range of users or potential users of AI in an arbitration may need to be widened. It follows that it may not be appropriate for a tribunal to simply adopt in a procedural order one version or the other of the guidelines of this particular guideline 3. That said, this guideline may be a suitable starting point when the tribunal discusses with the parties the use or potential use of AI in an arbitration. When raising this with the parties, a tribunal should not, however, be surprised if the parties, or more precisely, their counsel, do not share the tribunal's enthusiasm for disclosure. Some may draw comparisons with the traditional case databases, the use of which does not need to be disclosed. This apparently touches on the more philosophical question of whether AI is just a tool or whether it is something more than that. Of a more practical nature are concerns of privilege, which may also be raised in this regard. So, whilst there may be reasons for non-disclosure, given that the ultimate goal is to render an enforceable award, for the reasons I explained earlier, it might be prudent for the time being, until the legal framework on AI has become clearer, to err on the side of disclosure, even if that is limited. In the discussion on disclosure, one matter that may very well be raised by the parties is whether the arbitral tribunal, or for that matter, a tribunal secretary, may use AI, in particular, whether AI may be used when drafting any decisions. Of course, the employment of AI in decision-making is the elephant in the room. Again, the views differ, ranging from a total prohibition to embracing AI in decision-making, at the very least, insofar as low-value claims are concerned. It is common practice to engage, with the parties' consent, tribunal secretaries to perform a range of tasks. These may well include summarizing the parties' respective cases on the issues in dispute. Providing a summary of, for example, pleadings is, however, what AI tools are quite capable of generating. Should a tribunal therefore be permitted to use AI tools within the same boundaries as would apply were it to employ a human tribunal secretary? It appears that, at least for the present, the use of AI tools by tribunals, and by extension tribunal secretaries, is riddled with inconsistencies. It may not therefore be surprising if the parties wish to expressly exclude such use in an arbitration. Further aspects the tribunal and parties may wish to consider in their discussions on AI include the use of a memorial-style arbitration procedure. This seems to be the simplest way to address possible references to bogus legal authorities. Whilst not all tribunals favor memorial-style pleadings, they seem, at least presently, to serve and to have an edge over proceedings emulating more closely common law litigation, where copies of legal authorities are filed later in the proceedings. Also, there is general consensus that the use of AI could add further dimensions to well-known aspects of the arbitral process, such as the need to safeguard confidentiality, or on the prohibition of fraudulent or disruptive conduct. But it may not be necessary for tribunals and parties to spend too much time on these, or to include specific provisions in procedural orders to cater for these. This is simply because these are aptly covered by the existing legal framework governing arbitral proceedings. With or without the use of AI, the ground rules remain the same, and an arbitral tribunal will be able to rely on these also when addressing matters relating to AI, should such matters arise in the course of an arbitration. Earlier, I referred to the tribunal's duty to ensure the enforceability of the award. Concerns have been raised that the advent of AI in ADR could put at risk the fairness of proceedings. Others opine that this is a mere matter of competition, in that counsel using AI is likely to have a competitive advantage over counsel who does not. Current market developments, however, give cause for optimism, with more and more providers offering AI tools for the legal profession. Provided AI tools are widely accessible and affordable, these could contribute significantly to leveling the playing field. Indeed, over time, given the astonishing capabilities AI tools have demonstrated in mock legal exams and mock bar exams, their use may well become mandatory for lawyers in discharge of their duties to their clients. At the end of the day, if the preference of the tribunal and of the parties is for the use of AI tools to be excluded altogether, and I'm not suggesting for one moment that this is what tribunals or parties should do, one does need to tread carefully. This is because the prohibition on the use of AI should obviously not affect the party's ability to employ existing tools which are and which in the past had been commonly used. This applies in particular to programs experts use. And against this backdrop, how AI is defined in the procedural order prohibiting its use becomes crucial. These are just a few of the matters tribunals and parties may wish to keep in mind when discussing the use of AI in arbitral proceedings. Of the matters the ADR community may need to consider, two are the selection of arbitrators and the use of AI by arbitral institutions. On the selection of arbitrators, it is reasonable to assume that data in the public domain, such as papers, awards, and judgments rendered in respect of arbitral awards, has even before the emergence of AI been used by parties when considering who to nominate. It is equally plausible that where nomination was not available to a party, for example, in respect of the tribunal chair, a party may have chosen counsel with prior experience of the chair. AI, however, pushes these boundaries further. Using the tribunal members' publicly available information, AI tools are already there or will soon be able to provide suggestions for counsel on which evidence and even arguments counsel should focus on. Taken to its ultimate conclusion, in order for such AI tools to be able to realize their full potential, would it not follow that there will be a tendency for a party to appoint a well-established arbitrator simply because more data will be available on this arbitrator, data which the AI tool can then use in the course of the arbitration? This may be a cause for concern. The past decade has seen a long overdue push by the ADR community towards diversity and inclusivity. Would it not be detrimental to the tremendous efforts that have been made and the significant ground that has been gained if arbitrators are chosen by algorithms, if these favor the established and leave out the newcomer? What then of arbitral institutions? It does not seem too far-fetched to assume that certain aspects of the scrutiny process could be carried out by an AI tool, the least complex of which is proofreading. However, if AI is able to analyze evidence, could it not just as easily analyze awards? Will we see challenges to awards empowered by AI? Could it be as simple as uploading the award and asking, can this award be challenged? Or could the question be posed, can enforcement of the award be resisted in jurisdictions X, Y, and Z? If so, would it not be incumbent on tribunals and arbitral institutions alike to run the draft award through an AI algorithm to avoid as much as possible the risk of a challenge or refusal of enforcement? Drawing then to a close, I very much hope you did not get the wrong impression. I am not against progress, even if it comes in the form of AI tools. Although personally, as some of you in this room will know, I much prefer progress in cars. And even though at present, there remains a significant degree of uncertainty on the use of AI, tribunals have already begun to lay the ground rules on its use. We have seen similar developments in the past. Something new comes up. At first, it may be met with skepticism and perhaps even puzzlement. But then, on closer inspection, one finds that existing rules and first principles are more often than not of great assistance in response. Equally helpful is the flexibility with which the arbitral community is able to and does adapt. That it does so is not by chance. The foundation we all work on allows us that flexibility. There can be no doubt that the legal profession, including the ADR community, is on the cusp of a pivotal change. Yes, there's a new world out there, and whilst we may need to redraw our maps, we are not, I suggest, left adrift. Thank you.
The Honorable Mr. Christopher Lau, Senior Counsel and Chartered Arbitrator of 3 Verulam Buildings Barristers, has delivered a wonderful keynote speech titled New World, No Map. Thank you very much once again, Mr. Lau, and we would like to extend our sincere appreciation once again. So with that, we are going to conclude the opening ceremony of the 12th Asia-Pacific ADR Conference. Once again, we would like to express our heartfelt gratitude to all of our distinguished speakers who have shared their profound expertise with us today. Thank you very much once again. And now we're going to take a short break for about 10 minutes. And the next session, session 1, will start at 10:30 a.m. on the Korea Standard Time. So please enjoy your break and please come back to your seat on time. Thank you.